Welcome. This is Surya Kundeti, and I'm going to give an introductory lecture on the topic Civil Procedure Code 1908. In this class, I'm going to give you a brief introduction to the first unit, which is Introduction to Civil Procedure Code 1908. In general, the laws are divided into two groups. The first one is substantive law, and the second one is adjective or procedural law. Substantive law determines rights and liabilities, whereas adjective law, procedural law defines the procedure and machinery for the enforcement of those rights and liabilities. Efficiency or substantive laws to a large extent depends on the quality of procedural laws. Procedural law is thus an accessory to substantive law. Famous maxim, we have a very famous maxim called as ubi zu, ibi remedium, which means that where there is wrong, there is remedy. Substantive law. In Indian Constitution, we have substantive laws called as the Indian Contract Act, the Transfer of Property Act, Industrial Disputes Act, Indian Penal Code. All these are substantive laws. Whereas coming to procedural laws, we have Indian Evidence Act, the Limitation Act, the Code of Civil Procedure, and Code of Criminal Procedure. Now, some of the laws have been changed as BNS or BNSS and BSA 2024. The Code of Civil Procedure regulate the proceedings to be followed by civil courts. What is the history of this code? As per the records, the first Uniform Civil Code was enacted in 1859, and before this date, there is no record of having an Uniform Civil Code. There were many defects in the first code, and later the code is amended in 1877 and for one more time in 1882. In 1908, we had a great code which is now called the Code of Civil Procedure 1908. It was later amended in 1951 and again in 1956. The following considerations are obliged. What are those? A litigant should get a fair trial in accordance with the accepted principles of natural justice. Every effort should be made for the disposal of civil suits and proceedings so that justice may not be delayed. The procedure should not be complicated and should, to the utmost extent possible, ensure a fair deal to the poorer sections of the community who do not have the means to engage a pleader or an advocate or an attorney to defend their cases. Some of the important changes made by the Amendment Act 1976 are as listed. I'm going to tell a few of those things. The doctrine of res judicata or judicta is being made more effective. Power to transfer proceedings from one high court to another is given to the Supreme Court. Freedom from attachment of a portion of salary to all salaried employees is granted. Provision of giving notice under Section 8 before the institution of a suit against the government or a public officer is made less stringent. Restrictions are imposed on the right of appeal and revision also. Provisions are made to ensure that written statements and documents were filed without delay. New order, which is 32A, has been inserted to provide a special procedure in litigation concerning the affairs of a family. The practice to pass a preliminary and final decree in certain suits is abandoned. Scope of summary trials is substantially widened. Important changes have been made to provide relief to poorer sections of the community. And some more important amendments made in 1999 and 2002 in several matters such as issuing of summons, filing of written statement, amendment of pleadings, production of documents, examination of witness, pronouncement of judgments, preparation of decree, etc. A time limit is prescribed. A new provision for settlement of disputes outside the court has been introduced. Number of adjournments have been restricted. A provision for recording of evidence by the court commissioner has been made. Endless arguments are sought to be shortened by empowering the court to fix a time limit for oral arguments by preparing written arguments to the placed on record by the parties. Provision is made for filing of appeal in the court which passed the decree. Institution of appeal against the judgment is allowed where the decree is not drawn upon. Scope of second appeal, letters, patent appeal and revisions has been curtailed. So these are all the points or the amendments that were made from time to time. Now we can see the commencement of the code, how, when and effective on what date the code has been commenced. The Civil Procedure Code 1908, which is also 5 of 1908, came into effect from 1st January 1908. With the Amendment Act 104 of 1976 came into force from 1st February 1977. The CPC Amendment Act 2002 received the assent of the President of India on 23rd May 2002 and came into force on 1st July 2002. Consolidation and codification of the code. Consolidate means to collect all the laws relating to particular subject so as to make it useful at the time of consolidating act is enacted. So this is about the commencement. Next one what we have is extent and applicability of the code. Extends to the whole of India. Fascinating fact is before 1976. And what is the objective of the code? The objective of the code is a procedural law is always in aid of justice, not in contradiction or to defeat the very object which is sought to be achieved. A procedural law is always subservient to the substantive law. Nothing can be given by a procedural law which is not sought to be given by a substantive law, and nothing can be taken away by the procedural law which is given by the substantive law. It's all very well to paint justice blind, but she does better without a bandage round her eyes. She should be blind indeed to favor or prejudice, but clear to see which way lies the truth. So what is the scope? The scope is, this code is not exhaustive. The code is exhaustive on matters specifically dealt with by it. However, it is not exhaustive on the points not specifically dealt with therein. The court has inherent powers to act according to the principles of natural justice, equity and good conscience. The code specifically provides that nothing in this code shall be deemed to limit or therewise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of process of the court. So what is the interpretation of the code? Though substantive laws are very important, importance and value of procedural laws cannot be underestimated, but the procedural law must be regarded as such. The function of adjective law is to facilitate justice and hence further. A hyper-technical view should not be adopted by the courts in interpreting procedural laws. A party cannot be refused just relief merely because of some mistake, negligence, inadvertence, or when infraction or the rules of the procedure. So beneath the words of a provision of law, generally speaking, there lies a juristic principle, and it is a duty of the court to ascertain that principles and also implement it. As far as possible, no proceeding in a court of law should be allowed to be defeated on mere technicalities. CPC is to subserve and advance the cause of justice rather than to defeat it. We must always remember that procedural law is not to be tyrant but a servant, not an obstruction but an aid to justice. It has been widely observed that procedural precautions are the handmaid and not the mistress, a lubricant, not a resistant in the administration of justice, where the non-compliance through procedural will thwart fair hearing or prejudice doing a justice to parties. The rule is mandatory. But grammar apart, If the breach can be corrected without injury to a just disposal of the case, we should not enthrone a regulatory requirement into a dominant desideratum. After all, courts are to do justice, not to wreck this end point of technicalities. This was very, very well said by Krishna J. Iyer sir, the prominent Chief Justices of India. What is the scheme of the code? The CPC is divided into two parts. Body of the code, the schedule, the first schedule. The body of the code cannot be amended except by legislature, as it is fundamental. The procedure of the code can be amended by the High Court. If the rules are inconsistent with the sections, the later will prevail. Retrospective operation, this is very, very important. It is well settled principle of interpretation that procedural laws are always retrospective unless there are good reasons. The code of CPC is not retrospective in operation. So what is the code at a glance? Now, the Code of Civil Procedure contains 158 sections. The first schedule comprises 51 orders and rules providing procedure. So in brief, section 1 to 8 are preliminary in nature. Section 1 provides for commencement and applicability of the code. Section 2 is a definition clause and a sort of statutory dictionary if important terms used in the body of the code. Section 3 to 8 deal with the constitution of different types of courts and their jurisdictions, which is very, very important. Part 1, Section 9 to 35B and Orders 1 to 20 of the first schedule deal with suits. Section 9 enacts that a civil court has jurisdiction to try all suits of a civil nature unless they are barred expressly or impliedly. Section 10 provides for stay of suit. Section 11 deals with a well-known doctrine of res judicata or judicata, which is very, very important. Section 13 and 14 relate to foreign judgments. 15 to 21A regulate the place of suing, and section 22 to 25 make provisions for a transfer and withdrawal of suits, appeals and other proceedings from one court to another. Orders 1 to 4 deal with institution and frame of suits. Order 5 contains provisions as to issue and service of summons. Order 6 deals with pleadings. Order 7 and 8 relate to plaints, written statements, set-offs and counterclaims. Order 9 requires parties to the suit to appeal before the court and enumerates consequences of non-appearances. Order 10 enjoins the court to examine parties with a view to ascertaining matter in controversy in the suit. Orders 11 to 13 deal with discovery, inspection and production of documents and also admission by parties. Order 14 requires the court to frame issues. Order 15 enables the court to pronounce judgment at the first hearing in certain cases only. Order 16 to 18 contain provisions for summoning and others. Order 19 empowers the court to make an order. Section 75 to 78 and Order 26 makes provisions as to issues, commissions. Section 94 and 95 and Order 38 provides for arrest of a defendant and attachment before judgment. Order 39 lays down the procedure for issuing temporary injunction and passing interlocutory orders. Order 40 deals with appointment of receivers. Order 25 provides for security of costs. Order 23 deals with withdrawal and compromise of suits. Order 22 declares effect of death, marriage or insolvency of the party to the suit. Section 33 and Order 20 deal with judgment and decrees. Section 34 makes provisions for interest. Section 35, 35A, B, Order 28 deal with costs. Section 79 to 93 and orders 27 to 37 lay down procedures for suits in special cases. Section 96 to 115 and orders 41 to 47 contain detailed provisions for appeals, reference, review, revisions. Section 116 to 120 special provisions relating to High Court. Section 121 to 131 enables High Courts to frame rules. Section 132 to 158 relates to miscellaneous proceedings. So these are all the sections and the orders that are present in the Code of Civil Procedure 1908. This is just an introductory class and this class is dedicated to a charitable organization. And I am doing this online teaching or online classes as a charity to our organization. I am of the opinion that you will definitely like this charity classes, my teaching and other things. And in this context, I would like to request if you are happy and if you are considerate enough, you can donate rupees 59 to the charitable organization. The name of the organization is ABC Trust. And you can make the donation through an UPI transfer. The amount can be transferred by UPI to the following phone number or the UPI number, which is 9949398998. And a QR code is also going to be shared at the end of this video, wherein you can use it for scanning through your phone and make a charitable donation of 59 rupees to this one. Thank you once again and namaste.